We're back. Welcome back, everyone. Part 2 of the series, Being an Executor. We've got Susanne on the line again. And when we finished our last webinar, we got to the stage where we wanted to know if the executor could opt out of this predicament that the person is in. But now we're going to fast forward and we're going to say, okay, I'm going to do this job. So now that the executor's opted into the role, Susanne, we're going to jump right into this, by the way. What's next?
Right, exactly. So you've done this investigation, you're reasonably comfortable about assets and liabilities, you've arranged the funeral, that's all taken care of. Your next step is really to preserve and protect. So you're still in the figuring things out mode, but for example, in the preserve and protect stage, what you're doing is you're double checking things like if there's real estate, making sure that it's secured, the locks have been changed, make sure that there's valid insurance if it's vacant. Same thing for a car, any other type of estate asset, you have to make sure as the executor, you're now in control, making sure that everything is protected until you get to the point where you actually have legal authority to start selling and transferring. The other thing that's really important that some people miss is a lot of us have automatic debits and deposits on our bank accounts. And so it's really important for the executor to kind of dig in a little bit just to make sure that if there's any automatic debits that you make other arrangements, because usually banks will actually freeze those accounts once they have word that a person has been deceased. So you want to make sure that you're not, voiding insurance for non-payment because you didn't realize it was coming out of a frozen bank account. And then finally, you want to get to the point where you're canceling and redirecting mail, subscriptions, all of that sort of stuff, which, again, depending on your investigation of the client's, mail and assets, that can take a varying amount of time. And once you are relatively secure that you've done that, then we get into the probate stage of things.
Cool. So I just have a question about that. Is there a best practice, I guess, for a person to do so that they can make this job easier for the executor? Because maybe, I'm the executor for somebody and I'm starting to look for all the assets, but I have nowhere to look. I don't know where to look. So is there a best practice that somebody should do prior? Obviously you're planning to die, I guess, but is there a best practice?
So on the planning side, obviously what you want to do is make sure that you've got a paper trail that's easy for your executors to follow. So, you've got a list of where all of your assets are located, so banks to contact, subscriptions, etc. On the executor side, you can speak to your advisor, etc. They will usually have checklists for an executor to look at least sort of be a guide in terms of, right, don't forget to do this, don't forget to do that, because you're right, there's a lot of very specific tasks that you kind of have to do, and it's really easy to forget about something. But really in this stage, you have to think about all of the assets that are there. You might not be able to deal with them right away, but how do we make sure that they're secure so that nothing happens to them in the meantime?
Yeah. So if anyone's interested, we actually do have the checklist for you. We can give that to you. We also have the financial logbook, which you can log all of your accounts, everything, so that when the time happens and the executor needs to take some action, it's easy enough for them to do the job. Okay. So you just talked about probate. So what is probate?
Yep. So this is a question I get quite a bit. It's a really important aspect of an estate administration. So essentially, I have to take a step back just so that we kind of understand the background here. So when someone makes a will, they appoint an executor. So when a valid will is made, the executor technically has the authority to start acting right away. As soon as the person passes away, I should say, not when the will is made. As soon as the person passes away, they derive their authority from that will. However, in our common law system, someone can make and update wills as many times as they want before they die. So that means during someone's lifetime, there could be multiple wills out there. In Ontario, especially in common law provinces, we do not have a central way to keep track of all these wills. So the problem becomes that You know, if you're, let's say you're you're a bank employee and someone shows up with a will saying, hi, I'm the executor, please pay me this money as per this will, you do that. And then a few months later, someone shows up with an entirely different will wanting the assets paid to them. Well, you know, as a bank or a financial institution, you have a real issue there because you're not able to determine which one's the valid will or not. Same thing goes for things like real estate. You want to make sure when you're transferring title that you're transferring it to the right person based on the will. So the probate process is in place to really help these third parties ensure that the will is actually the last will and testament of the person. So what it is it's an application process that the executor goes through. So the onus is put on the executor to actually find the last will and testament and then go through the courts, provide information and evidence, information about the asset. The court takes a look at it, says, yep, everything looks good. They issue a seal on that document. That's sort of the probate certificate. And that is the proof that these third parties, like the bank or the land registry office, is going to rely on before they accept the executor's word that this is actually the last will and testament. This is sort of the extra proof that they need before they'll start acting on the executor's instructions.
So I guess in really basic terms, probate is checking the validity that it is the last will.
Exactly. Yep.
Perfect.
100%.
So I know that people always talk about probate, and there's always a fee. People are like, probate means fees. There's a fee attached. How much is that? And let's just talk about this fee, probate fee.
Exactly. So people tend to sometimes get confused between what is probate and then what's the probate fee. So probate is that process that I just talked about. It's a way for the executor to truly be able to show to the world that they have the authority to move forward with the transfer. What the court does, though, is in order to issue that probate certificate, they levy a fee. It's a tax. We call it informally probate fees, but it's actually a tax. It's based on the value of the assets that are passing through the will. And the percentage that they levy is 1.5% on the assets that pass through the will. Now, you'll notice that I keep repeating pass through the will, and that's really important because that fee is not levied, or that tax is not levied on all of the assets of the estate. It really depends on whether the will needs to be presented in order to transfer that asset. So for example, let's say you have an RSP or a TFSA or life insurance that has a beneficiary designation that's been done with National Bank's office. So what happens in that case is that the executor isn't involved at all after that person passes away. The beneficiary, because the deceased has already done a beneficiary designation, that asset can actually pass directly to those beneficiaries upon the presentation of a death certificate. So what that means is the will and the executor is not involved, so therefore you don't have to include that when you calculate out what the fee is going to be. Same thing applies to things like jointly held assets, especially between spouses. So, real estate, bank accounts, and also the fee doesn't apply to any real estate held outside of Ontario.
Yeah, so I guess 1.5% on non-registered assets or solely owned assets. Those are the ones that would get charged as probate fee, correct?
Yeah, that is usually in most straightforward estates, that's the case. So it'll be non-registered assets, so investment accounts, as well as real estate in Ontario that's not held jointly between two individuals. And again, that gets more complicated, but for the purposes of this presentation, we'll say jointly held real estate is not included.
Okay, cool. Yeah, that's so that could be quite a lot of money. I mean, if it's $1 million with that 1.5%, you could be forking out quite a bit of dough, right? So I guess I should bring it up maybe that there are strategies out there to reduce the amount of probate, and we would be gladly able to talk to you about that, Suzanne, myself, and Sheck. Why don't we go down to the next question here? So can probate be done by the executor themselves, or should they, should they seek help? I mean, this is a pretty big job to make sure that will is valid, right?
Exactly. So I mean, we have to distinguish between can they do it themselves or should they do it themselves? Those are two different questions. So yes, technically, you know, if you Google, you can find all the forms that you need to fill out online in order to do a probate application. But the thing to keep in mind is it's pretty complicated, and the vast majority of people will need to seek legal assistance in order to do that. The reason being that there's so many twists and turns and complexities in these applications. They look straightforward, but having been in private practice for a number of years and having done hundreds and hundreds of these, I can tell you that it can sometimes come down to, you know, a typo in terms of a misspelling of a name that ends up having the application be rejected. So I like to tell the story of a family that decided that they wanted to go ahead and try to probate without my help because they didn't want to pay my fees. They actually came back to me 4 months later because they were so frustrated because they kept getting the application rejected that they finally just turned it over to me and said, "Go, we don't care, we're going to pay the fee." So, you know, it's one of those things where if you're not doing this type of thing every day, save yourself the stress and the hassle. Just pay the lawyer fees, and then you don't have to worry about it. You know, let it be the lawyer's stress to get that.
I don't know if this is a statistic, but is there, like, out of all the wills that are probated, like, how many of them actually seek legal advice? Do you know? Like, out of 100 people, is there a statistic on that or no?
I have absolutely no idea. I would say if it's going to the point where it is going to, the will has to be probated, I would say that the vast majority will seek legal assistance. Again, it's again, one of those things, you know, there's certain tasks that I'm not going to do because I have no idea what I'm doing. I've never tried it before, right?
Yeah.
So this isn't the time to try to save a few dollars in order to get this done, because not getting probate can have real implications as well, right? Because in many cases, as I talked about before, you can't start moving around or transferring assets until you get that probate application. So, you know, you got to weigh the pros and cons. The more you delay, the longer it's going to take to administer the estate.
So, and another fee, I guess. You got to pay a lawyer to get the probate done.
Nature of the business.
Yeah, exactly. So, okay. So now that probate has been obtained, you've gone to the lawyer and you said, okay, I need help with the probate. Is the executor done their job, or is there more to do?
Yeah, so, you know, as I'm sure you can imagine, that's not where things end. So what probate does is it conveys that there's legal authority for the executor to start transferring assets from the estate. Okay, so it's step number one. So now the executor can show up and actually start dealing with those assets under the estate. So what that means is that now the executor takes the next step and they have to actually start transferring those bank accounts. They need to pay the income taxes. You know, you engage an accountant, pay those income tax fees. You sell the real estate finally, and everything that is involved in that aspect of it. And then you actually have to have a good understanding of the will, because then it's time to start transferring those assets to beneficiaries. And there's a little bit of a pressure there, because one thing I didn't mention under the probate application is that you actually have to give written notice to all the beneficiaries that you're applying for probate. So they've received this letter saying, okay, this estate is about to be administered. I'm going to be a beneficiary. So once probate is obtained, you know, pressure's on a little bit for the executors to start taking those steps in order to transfer assets, because you've got beneficiaries on the other hand, on the other end, who are waiting for their inheritance.
Yeah, wow. It seems like a lot of work. I mean, so from the date of death to about this point in the process, how long has it been so far, do you think? Has it been 6 months, a year?
So, I mean, I can only speak from my anecdotal experience in Ottawa. So for most people, if it's, let's say, a parent's estate that you're administering, which is, you know, where probate's really going to come into play most of the time, usually once the person passes away, it takes a couple of months to get yourself organized enough to actually apply for probate. Once you apply for probate, it really depends on where you live. So, for example, in Ottawa, when I was practicing, it took 4 to 6 weeks from the date of the application. I have heard, if you're in downtown Toronto, for example, because they're so backed up, it can take a year sometimes to get probate. I've heard 6 months in Mississauga. It varies across the province. So this is something that is a variable that you can't really control, but maybe as quick as a few weeks, it may be a year. It really just depends.
Okay. Now, the executor is now giving the beneficiaries the money and the house or whatever, that they're delivering the money and everything. So is there any legal liability on the executor during this process? So the reason why I ask is, what if there's like more liabilities than assets or something?
Yeah, so this is why we spent so much time in our last presentation. So if any of your clients have not, or any participants have not reviewed that, they should go back and take a look at it, because really this is the investigation part is extremely important, because if you don't take that time up front to really understand what you're getting yourself into, there may be legal liability to you personally. And that is because the executor, when they take on that role, especially when they've gone as far as to apply for probate, which is a public declaration to the entire world that you are taking on this role of administering the estate, it's really hard to turn back at that point. You're in. What a lot of people don't realize is when you're acting as an executor, you're taking on also the duty to more or less preserve and optimize the estate for the benefit of the beneficiaries. So what that means is, if you fail to do something, if you are negligent, if you're, dragging your feet, if you make a mistake, and those errors or omissions or problems, if they result in financial loss to the estate and to the beneficiaries, you might be legally liable for that loss. So it's, again, really important that you understand what you're getting yourself into when you become an executor, because if there is a problem, you're the final word, the final stop. You're the one that has the authority. So again, this is why that investigation part, really making sure you understand the circumstances, making sure you understand who the beneficiaries are. If it's someone who is going to create problems, you might want to think twice about taking on that role, because once you're in, you're in.
So I guess if I was the executor and I paid out the beneficiary, say it was a RIF account and it had $100,000, and I gave it to the beneficiaries, but I hadn't done the final return and there's still money owing, I guess the beneficiary is not going to give me the money back, right?
Well, this is again where lawyers really get to come in and show, and make their living, right? So there's ultimately, CRA will not let that go, right? The taxes need to be paid. Where they're paid from is, it's going to be the passive least resistance, right? So CRA has the power to go after beneficiaries if there's no money that's left over. If they can't, there's different aspects of it, but ultimately, if you start distributing something that should have been used to pay taxes or should have been used to pay off a debt, and you can't get that money back, you might be on the hook for it. So that's just, you really do have to be careful of. Yeah.
I guess I really don't want to be an executor anymore.
Listen, in some circumstances, it can be a long and arduous process, but ultimately there's no problems. I think where the problem comes in is that people don't, on the beginning side, they don't plan. I mean, that's just how it goes, unfortunately.
Wow. So yeah, that's a lot of responsibility, that's for sure. Okay, so now that everything else is being kind of complete, do you distribute the assets like before this final tax return? Is what else is left? Is there some like I'm a little lost here now.
Yeah, no, absolutely. And so this is going to be an ongoing process, right? So what we're really concerned about for most people is that, okay, beneficiaries, you can, there are ways that you can negotiate with them. Other creditors, business owners, etc., if money is owed to them, you can usually negotiate with them. CRA, on the other hand, is not going to go away. And
Yeah.
so the issue there is that you really want to make sure tax liabilities have been covered off to some extent. And so the good thing for an executor is that there is a process whereby they can actually assure themselves that CRA is not going to come after them, 5-10 years later for unpaid taxes. And that's applying for what's called a clearance certificate. So this is usually done towards the end of the administration of the estate. There's a number of, a lot of information that's given, but essentially what happens is CRA issues something that says, yeah, we're good. We're not going to reassess this person or this estate for any other unpaid taxes. And that's, again, it's a matter of managing risk. So there, the executor can be reasonably confident that they're not going to have to find other money to give to CRA because CRA is satisfied. From a timing perspective, again, it's not done in every estate. So, if you're managing the estate of your deceased spouse, and they were a salaried employee their entire lives, and you're receiving everything, I mean, the odds are that there's a hidden tax liability is probably pretty slim. So you might not want to take those extra steps. But if you're an executor for someone that you don't know very well, and there's 20 beneficiaries, and you don't have a good handle on what they were doing in their lives, then that is sort of the scenario where you would want to go that route, just to make sure that you're covered off from a liability perspective.
Wow. Okay. So yeah, I guess so. The last thing is the final tax return, pay out the beneficiaries, and then this clearance certificate.
Mm-hmm.
And then you wipe your hands off and say I'm done, and I'll never do it again, right? That's what most people probably think after they do one.
I mean, exactly. I mean, I don't think I've ever had anyone come back to me after an estate and say, that was really fun. I'd like to do that again. It's usually very much the opposite reaction. So again, there are times when the benefits outweigh the risks or that sort of thing. But for the most part, it's not a pleasant experience for people to go through.
Yeah, I guess especially too when there's a lot of different moving parts and it's not straightforward. I could see this being a very difficult process. I mean, if it was just a couple registered accounts in a house that was jointly owned with a spouse, it's not that hard to do. But yeah, I can see how it can be very, very difficult.
Yeah, and then that's where I just want to plug in the importance of the planning aspect of it, right? So the whole idea behind planning is to make it easier for those executors who are then kind of stuck with this role. So it really is in order to kind of lessen the risk that someone's either going to renounce or that they get in trouble. You can already start with making sure that your estate has been planned out properly. And then that will also help to reduce some of the issues that an executor may have going forward.
Yeah, so state planning process is absolutely integral. I recommend it to absolutely all of our clients. It's one of the first things I talk about when we meet with new potential clients, having the wills done, the powers of attorney, making sure everything's kind of planned out the way you want it, because it can be misconstrued, I guess, if you don't, right? And you don't want that either.
No.
And sometimes it's hard to leave, one house to, two kids and they don't even like each other. But you know what I mean? So there's different ways that we can talk about it, and we can give you ideas, and then this whole planning process. And so what ends up happening is you work with myself and Susanne and Sheean, and we give you this nice, beautiful document. And essentially you take this document to the lawyer and it becomes a will and everything's done, right? So, and then obviously when things change in your life and you need to relook at the thing, we sit down again and we update the document, and then you essentially go back to the lawyer again. This whole process is something that's included in our services for our clients. I mean, if you were to go to an estate lawyer to get it all done, that's an extra cost to you. So again, lawyers charge hourly, so you're going to get a little bit more higher of a fee just to get something done like that. Susanne, anything else you wanted to add? I think this was an absolutely amazing experience for all of our clients. This conference was great. It is going to be going up on YouTube, so we will be sending that out. But anything else to add? No,
I think we've done a good job of sufficiently scaring people off of the role of acting as a executor. So I think my work here is done.
If there's anyone that likes doing being an executor, it must be you, right, Susanne? You do this stuff all the time.
Well, listen, I mean, I get paid to do this sort of thing, so.
That's a great dinner topic, I'm sure. All right, everyone. Well, thank you very much. We will be back in a couple weeks. Stay tuned for the email, and we will see you then. Thank you very much, Susanne, and thank you very much for everyone tuning in. Bye-bye.
Bye-bye.